Hello, everybody, and welcome back to Clat Tutor. This is the third video in our series discussing the Indian Contract Act. Till now, we've discussed what are the essential parts of a contract, in which we've discussed offer and acceptance. We've also discussed what makes a contract enforceable, where we've discussed consideration, object, and capacity. Today, let's start by looking at consent. Now, as we've already discussed, in order to make a legally enforceable contract, your consent must be free. That means your consent must not be influenced by coercion, by undue influence, by fraud, by misrepresentation, or by mistake. Coercion basically means that if a person threatens you, that if you do not agree to the terms of the contract, commit a crime, and because of which you do agree to the contract, the same is said to be vitiated by coercion. For example, if a person blackmails you by saying that they will kidnap a member of your family if you do not enter into a contract with them, the same is the contract is then vitiated by coercion. This means that the contract becomes voidable, and it is at your option that the contract will survive or not survive. Undue influence is when a person who is in a position of power to you ends up influencing your decision regarding you entering into that contract. So, this can be a position of power of a teacher and a student, an employer and an employee. They exercise undue influence on your decision. Fraud is when a person knows that they are giving you wrong information about a thing which is really important for you to enter into that contract, but they still end up giving you that wrong information and you enter into the contract. The same is vitiated by fraud, and you do have the option of ending the contract. Misrepresentation is very similar to fraud, except that the person giving the information does not themselves know that this is wrong information, but you do get wrong information at the end of the day and enter into the contract, which is also against the concept of free consent, and hence the contract will not be enforceable. Lastly, we look at mistake. This is when both parties to the contract are under a mistake with regards to something very fundamental in the contract. For example, let's say that you want to buy a horse, and you and in person X decide to enter into an agreement for the same. However, at the moment you were entering into the contract, the horse was dead, but neither of you knew of this fact. This contract will then be vitiated by mistake, and the contract will be considered to be void. Let us now look at enforceability. Now, enforceability basically means that this contract is one where you could approach a court in case things go wrong. And if you can approach a court, then this contract will be said to be enforceable. The first aspect we need to study is what is a void contract. Now, we've studied that contracts which have been entered into a person who is a minor or who is mentally unstable at that point of time are considered to be void contracts. This means that it is as if the contract never existed and the contract does not exist at that point of time when it is declared to be void. Secondly, a voidable contract is where one of the parties to the contract has the decision making power to decide whether they want the contract to continue or decide whether they want to declare the contract to be void. So, in short, voidable means a contract in which one party can avoid the contract. This is in cases where consent is vitiated. So, for example, if you enter into a contract under undue influence, then you do have the option to decide whether you want to continue in the contract or end it. Void ab initio is a Latin term which means void from the beginning. This is when it is as if the contract never existed from the beginning of which it was entered into. Lastly, we look at a breach of a contract. A breach of the contract is basically when you decide that the contract has been broken. It happens when either party to the contract does not fulfill their end of the bargain or does not fulfill their obligations. For example, if we've entered into a contract to buy a house, but you do not end up paying for the house in the time situation that is stipulated, then the contract is said to be breached. Now, what happens after the contract is breached? The party who has breached the contract will have to pay damages. Damages are basically monetary or non monetary compensation for breaching the contract. They can be liquidated as well as unliquidated. Now, liquidated damages are when the contract itself stipulates how much money is to be paid in case of a breach. So, in such a case, the court will look at the contract itself and look at the amount specified in the contract. It mostly occurs when the contracts are written. Unliquidated damages is when the parties themselves have not specified how much money is to be paid in case of a breach. In this case, the court themselves decides what is the amount to be paid after the contract has been breached. Now, there are three terms which are again relevant in the area of contracts. The first is frustration. Frustration happens when there is a change in circumstances after the contract was made, which is neither the fault of any parties, and now it renders the contract impossible to perform, or it changes the terms of the contract very fundamentally. For example, if I enter into a contract with a person in another country for them to deliver some goods to me, and after I've entered into this contract, both the countries declare war with each other and the borders are closed. This would amount to an event which changes the circumstances, and hence the contract can be said to be impossible to be performed, and hence the contract ends by the way of frustration. The concept of force majeure is when an unforeseeable circumstance happens that prevents a person from fulfilling the contract. For example, if a natural calamity happens which prevents a person from fulfilling the contract, the same would be declared to be force majeure. And lastly is termination. Termination is when both parties decide that they want to end the contract and hence not conduct the obligations under it anymore. And by consenting, both parties can end the contract, and hence the same is called as termination. This brings us to the end of our three-part lecture video series on the law of contracts. Hope this helped. Thank you so much for watching. Please do leave a comment or email us in case you have any questions.